So Lecture 3 Part 2, a work of architecture being a building or a model for a building. And this covers an actual building or any part of it. So next time you're in uni, which I hope you will be today at some point, have a look up at the building and you'll see that we have some wonderful engravings and wonderful relief mouldings and so on our building. And so all parts of the building would be covered under this section. And the plans, of course, will also attract copyright, but that would be as drawings. Now please notice carefully that the wording is a model for a building and not a model of a building. You make a model of a building, it's of a building that is already made, unless it's probably out of your imagination, but usually it's of a building that's already made. So you could go out now and make a wonderful copy of the university building, and that would be a model of a building. But a model for a building really covers the type of thing that architects make when they're drawing up the plans and they're putting in a tender. They want to get the money for a contract, if you like, for actually building something. So let's say, for example, government want a new main office for, I don't know, maybe for the Home Office, and they'll invite tenders from various different architects, and the architects will draw some drawings of how they think a new Home Office should look. Then they will make a model, and so that's a model for a building, and they will take it along, show the government what the building would look like if they made it. So that is what is covered under this section, a model for a building, not a model of a building, and it's very important that you understand the difference. So we'll move on now to works of artistic craftsmanship. Now, works of artistic craftsmanship need an element of artistic quality, but there isn't any definition as such in the act of artistic craftsmanship. We know that it covers such things as handmade jewellery, for example this, designer ware, hand-thrown pottery maybe, and crystal glasses. But there's no hard and fast rule that I can give you that will identify what will attract copyright under this heading, which is unfortunate and seems to be the case with an awful lot of the law that I'm teaching you. No hard and fast rules, no scientific basis. Well, this fell to be discussed in the case of George Hensher Limited and Rest a While Upholstery Lanks Limited, which is in your case list. And it was discussed in this case in the House of Lords, so it's our highest authority. Now, the protection that was being sought was for a prototype of a suite of boat-shaped furniture. So we're talking about a sofa and a couple of armchairs in a sort of a boat shape, and it was very popular in the 1970s. The appellants claimed that the prototype was a work of artistic craftsmanship under a similar section in the 1965 Copyright Act, obviously not the one that we're currently using, but it is still a good authority. Now, the reason that the protection that was being sought was for the prototype and not for the actual suite of furniture which you could go into any shop and buy, and it was called the Bronx Suite, was because obviously if it was being mass produced and sold on the open market, it couldn't possibly be a work of craftsmanship. It was mass produced, so you can't have, so that's something that's fairly obvious. Something mass produced can't be a work of craftsmanship. So they had to actually go for protection of the prototype. Now, the court at first instance held that the prototype was a work of artistic craftsmanship, but the Court of Appeal disagreed, and so did the House of Lords. Their lordships were agreed that in order to fall within this section, the object would have to be not just a work of craftsmanship, but also have an artistic quality, although how they were going to define the necessary artistic quality they couldn't actually agree on. Each gave differing tests for this, ranging from what was the maker's intention to whether a substantial section of the public admired and valued the thing for its appearance. So this case doesn't actually give us too much in the way of concrete assistance when we're trying to ascertain a very fine definition of artistic craftsmanship. But it fell to be considered again in the case of Merle and Mothercare, which is a case about a baby's rain cover. Again, the protection that was being sought was for a prototype. Now, here we have a French lady who was taking her baby up to Scotland for visiting with family, and I can tell you Scotland is very, very cold most of the time, not just in the winter. And she was trying to protect her baby from the elements, and she designed a cape to put the baby in to protect it from the elements. Now, Mr. Justice Walton held that the cape was a work of craftsmanship, but if considered on its own, it was not a work of artistic craftsmanship. Trying to find you a picture of one, but I don't think I've got one actually. What he did was he took into account that the intention of the maker, Mrs. Merlet in this case, was not to create something that wonderfully artistic that looked fabulous and so on, but simply to protect firstly her child and then the children of other people who bought the object, to protect the children from the cold. He did say that if you put it on a child and you took a photograph of the family with the baby and it wearing this cape, that it might look very artistic, but on its own the garment was not artistic. Now, Mr. Justice Walton's reasoning was rejected in the case of Shelley and Rex Features in 1994, which is also on your list. And this was a case about Frankenstein, the makeup used in the film Frankenstein. Obviously there is no such thing as Frankenstein, I hope. So it's copyright in the makeup that was used to create Frankenstein, that was in question. But was it a sculpture? In other words, you know, the prosthetics, the bolt through the neck and the square head, I suppose. Or could it be protected as a work of artistic craftsmanship? Also in the film there were obviously the film sets, and they were able to be protected as works of artistic craftsmanship. The judge said, considering the work in isolation rather than in context is too narrow when considering a composition such as this. He said it had been constructed and arranged to achieve a particular artistic effect. And we'll take a break there.